Welcome everyone, and thank you all for joining us today for this session. So we're very pleased today to be joined by Will Ellis and James Williams from BWHS Surveyors, primary care specialists. And we are all very much aware of the challenges in the GP sector in today's climate and how the need and demand for fit-for-purpose premises across the NHS estate has never been greater. This session intends to focus on some of the current issues we've seen arise with GP premises, and with both specialist legal and surveyor expertise, we discuss how we can best approach different situations and ensure we can best prepare for the future. And just by way of introductions, I'm Lisa Davison. I'm a partner in the real estate team at Hempsons and a primary care specialist myself. I'm joined today on the legal side by my colleague and primary care specialist, real estate senior associate James Molloy, as well as Will and James from BWH. And for those who are new to Hempsons, we are a national law firm specialising in advising the health, social care and third sector on all their legal needs, from regulatory employment disputes to property and partnership contracts and corporate law. And we act for hundreds of GP practices and their lenders across the country. So let's get started and look at today's agenda then. We've got it up on the screen there. We're going to look at 4 discrete topics today. So we've picked topics between us which are quite topical and would value both legal and surveyor input. So the first topic there is evaluations. We're going to look at consistency of approach with valuations. Then we're going to look at rental income and leased surgeries in particular. Then a very hot topic, partnership succession, and we'll finish off with funding options before we look at a Q&A at the end. And Will is going to take the chair for today's session and raise questions of the panel for each of us to discuss. And as Jess said, just a reminder, if anyone has any questions, if you pop them in the chat, and we'll tend to pick them up at the end of the session. But if anything is particularly relevant for that section, if we're talking about that, then we can cover that off in each section as we go along. So with that, I'll hand over to Will to look at our first topic, which is valuations.
Thank you ever so much, Lisa. Yes, okay. So yeah, my name is Will Ellis. I'm the Managing Director here at BW Healthcare Surveyors. I know we've got quite a lot to cover today, so I'm just going to get straight into it. So looking at the first section, valuation consistency of approach, can you explain why a valuation mechanism is important?
So I'll start with this one, and on reflecting on this particular question, I was thinking actually there's probably not a day goes by in which a valuation report doesn't come across our desk as property lawyers, whether it's for refinancing purposes, on the transfer of property between partners, or on a freehold transfer where partnership property is being transferred from outgoing partners to incoming partners. Also, we also deal with the transfer of freehold property from the partners to outside the partnership, where retiring partners may want to keep hold of property as a capital asset and then lease back to the partnership. Leasehold valuations and current market rent is largely dictated by rent reimbursement and the district valuer's value for money report, but we'll discuss that a bit later when we come on to the leased surgeries section. So where we have a partnership property held as freehold, as a partnership or capital asset, a third-party valuation is key when it comes to partners retiring from or joining the partnership. And just to end that question by saying that GP premises are very, very complex, and in order to facilitate that process and avoid disputes going forward, there must be a clear mechanism for determining that valuation. So that third party, so James, Will and BWH in this instance, know on what basis and on what principles to value the freehold premises.
Absolutely not. And hi everyone, I'm James Williams at BW, but essentially the mechanism in which we use to value our premises is really driven by initially the questions around what it is that we're valuing and why. in order to establish the how. And when we talk about mechanism from a technical perspective, we're talking about the approach or method to the valuation. And what we're talking about here are red book valuations, and many of you will be familiar with that phrase, a red book valuation. And what is a red book valuation? Well, the RICS, the Royal Institution of Chartered Surveyors, the full title of the red book is, as I've included on the slide, and it's a rather long-winded title, but essentially it's a group of mandatory standards and professional standards that have to be adhered to by RICS registered valuers. It's a set of global standards that incorporates international valuation standards and includes a UK supplement in relation to the UK itself. And essentially this sets out the process we go through in arriving at a valuation. It covers all aspects of engagement with the clients and practices, the agreement of terms of engagement, the assumptions and special assumptions, what they are, how we agree those, how we arrive at those, and also the reporting processes that we have to go through. It covers things like conflicts of interest, and really important and critically, the approach and methods adopted. So a valuer, RICS valuer, will have regard to this framework itself in producing valuations, and that's really essential to establishing the valuation, but also from a property specifics perspective. If we're talking specifically about a partnership valuation, we'll want to have regard to a partnership agreement or partnership deed that may or may not actually be in place. I've seen partnership agreements that have referenced elements of the building, for example, to be excluded as a requirement of the valuation. Very important assumption to make, because obviously if you don't follow that, you can lead to potentially significantly different valuations, which we'll come on to shortly. But initially, that's why the mechanism is important and the framework within which we operate as valuers.
Perfect. Thanks, James. Thanks, Lisa. So with that in mind, where can disputes arise? What's the most common kind of disputes that you both see and when dealing with these matters?
I don't think it will surprise anyone on this call to know that this is an area where disputes do often arise and keep our team very busy, particularly where we've got a deflated or uncertain market, as we have now. Actually, we have seen an increase in these type of disputes, particularly where there's no partnership deed setting out that basis of valuation. So some of the examples we've had recently is where retiring partners have bought into the practice during an inflated market, so obviously has a mortgage to that extent, very healthy mortgage secured on that basis. Years later, when that partner comes to retire and get the share in the practice valued at that time, the bank valuation is obviously a lot less than what they bought in for. So disappointingly, that's a situation where negative equity can occur. And I guess what happens in that situation, should the outgoing partner be forced to sell at that lower valuation? Should an independent valuation be obtained? What does that mean for the incoming partners in obtaining a mortgage on those terms? And should there be an option for the outgoing partner to keep their share in the property until perhaps market conditions improve? And then what happens to the notional rent in those circumstances? So that's an example where the valuation is key, and actually there's a lot of uncertainties which could be discussed and answered before we got to that stage to know how the partner should deal with that situation in those circumstances. We've also had situations where there have been a number of different valuations by different surveyors for the same property. So we had a situation recently where partners were looking to buy some neighbouring land for the purposes of an extension to the practice. And because we're talking about marriage values as well for the practice, the value of the land to the practice was worth a lot more than the value to any other third party. So there was huge discrepancies in the valuation of that land from a freehold point of view as well. So we would expect the partnership deed to set out a clear basis for valuation and provide what should happen should there be a dispute in those situations, and in particular what should happen in a negative equity situation, generally giving the outgoing partner a window in which to sell their share when hopefully market conditions could hopefully improve.
Perfect. Thank you so much. Lynn, look, as a company as BW Healthcare Surveyors, I mean, we undertake a number of valuations as as James will confirm, and sometimes our opinion can differ from that of other surveyors. So I just wonder if we can explain why valuations might differ and how that's regulated.
Absolutely. So it's initially with highlighting that a valuer's role is to reflect market sentiment as at the date of valuation for what it is that we're valuing. It is a professional opinion of value, and whilst that value is a fixed number, it isn't a fixed number in perpetuity, and it's based on a whole set of assumptions driven by the purpose itself. And it's very important sort of part of that. But what can cause differential situations with valuations is really two main factors. One are sort of external market forces, both locally and on a macroeconomic scale. So market sentiment, the effect of borrowing costs, the interest rates moving, things like that can shift market forces. And certainly if there's a time difference between valuations, this can lead to a bit of a bigger disparity. But other valuations can include the more detailed things like the mechanics of the valuation itself. Lisa, you touched on the difference in valuation of a marriage valuation, for example. A marriage valuation it's a fairly complex valuation involving the combination of two interests, really. And what you're looking to do is a number of valuations set within the one valuation. And actually, you can change one variable for a different reason, a different number of reasons. Actually, the end output can be fairly significantly different. So it's understanding the base on which we're valuing it. So the mechanics are really important, and that can lead to a difference of opinion as well. We've got a difference in the use of comparable evidence. It can vary on the applicability of evidence that is being used, or the relevance and how far away it is being drawn from. That can produce differences of opinions. And fundamentally, and as I sort of touched on sort of earlier, it's different assumptions that may be used. So if we're excluding part of a surgery, for example, or including part, or we're making a special assumption, I could, for example, be asked to value an extension that is partially completed and make the special assumption that it has been completed, and includes an assumption that the reimbursement from the ICB. Now, whilst the valuer would want to take further queries around that to look at how likely that is, that approach would be very different potentially to another basis. So there's all kinds of those component parts which can lead to a difference in valuation. This is driven, as we've touched on earlier, by the purpose of the instruction and the scope in which we're valuing it itself. And I think that leads me on to say, in terms of the RAICS perspective on where we have disparities in valuation and why we have them, they're quite clear that differences do exist, and it is valuation professional opinion that is being expressed. But essentially, if the Red Book is being complied with and the mandatory standards are being followed, then essentially this should limit that disparity. So things like evidence sources need to be very clearly agreed and set out within the report itself. The assumptions and limitations of the report, again, very clearly agreed with the client if they're not already established through things like a partnership agreement, and then running through other aspects, basis of the valuation itself and the methodology to ensure compliance with the Red Book. And thus overall, from an overall perspective, comparing two valuations done at the same time for the same basis should limit that disparity itself by ensuring compliance with those professional standards.
Perfect. Thank you ever so much for that, James. Okay, so looking at what you've both talked about, what advice do you have for practices who are wanting to perhaps have their surgery valued for whatever purpose that may be, maybe for partnership changes or whatever else? What advice do you have for practices going through that process?
That's all really useful, actually, listening to what James has to say on the ground from a practical point of view on how the valuations can differ and why. And I think, that just highlights as well the importance of keeping partnership deeds up to date, having these discussions with your partners early on so that you can determine on what basis those valuations should take place and also what should happen in the worst case scenarios.
Absolutely. It's being clear on the purpose of the valuation and kind of further leading on from that, it's engaging. I would recommend really engaging with the valuer to address any queries that might arise through any assumptions or the basis of the valuation itself. A valuer's role is quite investigative initially, not only in terms of the physical nature and aspects of the building, but any usages of the building as well. And we've already had a question come through related to how common it is for a valuation to include non-NHS income. And I would say the treatment of GMS and non-GMS space is really quite common within surgeries valuations. There could be elements where there are sublettings or lettings taking place, and it's how we treat that that is really important. How we make the assumptions we make around that, and that is an engagement with the valuer. It's a discussion around what it is we're trying to value here and why. So it's transparency between valuer and the partnership to understand, for example, if it's a partnership change valuation and there was a previous valuation done for the same purpose, it's really useful to make the valuer aware the mechanics of that, how it was arrived at. And it's not necessarily to mean that the valuer will produce a different opinion. It's for the valuer to then be able to advise whether or not there is a difference around consistency or why there may be a difference in the valuation and the reasons for it, and that can be discussed with the valuer. And finally, if anything is unclear with either the instructions, the valuation, or any queries, even once the valuation has been issued, it's really to engage with the valuer to try to understand and address those issues.
Perfect. Thank you very much. Right. Okay. So that's everything to do with valuations. Moving on to the next section, which is rental income and leased surgeries. So what specific terms can we expect to see in a GP surgery lease to kind of help future-proof the practice?
Thanks, Will. Hi, everyone. So just to mention in terms of the property title before we touch on a couple of specific lease points. So the land registry allows for a maximum of 4 partners to be named on the title register as the registered proprietors or the owners of the leasehold title interest created by the lease. And in the sort of traditional GP partnership model, the surgery premises are held by the named partners on trust as a partnership asset in accordance with the partnership deed. And then when we're talking about specific lease terms, the idea of a GP lease is just making sure to flexible vehicle so that if there are any changes to the partnership, for example, if a partner leaves or retires or if a new partner joins, the lease basically covers those events to ensure the surgery premises can still, and the business in general, can still so run as effectively as possible. So I suppose a couple of the main things we'd expect to see is the ability to assign the lease and also to share occupation of the premises. So with assignments, most commercial leases require landlords' formal consent if they want to assign the lease or transfer the leasehold interest to someone else. And with GP premises, assignment provisions will usually kick in if a partner leaves or a new partner joins the partnership, as I just mentioned. But usually GP partners don't require the landlord's consent to assign the lease, but there are still conditions that still have to be satisfied, even if consent isn't needed. So usually there needs to be a minimum of 2 partners who can hold the lease at any one time, and the partners also need to be entitled to the same level or the same amount of NHS funding received by the current partners immediately before that assignment. But the overall purpose of a GP is not requiring consent, is that it saves that administrative burden and costs of formally documenting that consent and satisfying numerous other potential conditions. Again, it's just to maintain that efficient running of the premises. And then in addition to assignments, a GP lease should also allow partners to share occupation of the surgery premises with third parties. So that could be other primary healthcare providers, it could be pharmacists, or it could be PCNs. And the thing about sharing occupation, that by its very nature, it's an informal arrangement and it's used on a sort of an ad hoc basis. There's no legal tenancy created by it. And so again, it gives that flexibility without the usual hurdles that you need to jump through, if you like. But the landlord should still be informed of that arrangement if partners are looking to share occupation. And also partners just need to be careful just to make sure any sharing occupation arrangement don't affect notional rent or rent reimbursement. So I think they're the two a couple of the main things that I would certainly look for when negotiating the GP lease on behalf of partners.
I would expect rent review provisions and rent review process to be very clearly covered in a GP lease, particularly from the perspective of protecting the tenant. So such that rent at review can't be any higher than what will be approved by the district valuer or determined via an appeals process. Now, interestingly, every time the premises cost directions are updated, it tends to change and override a lot of these leases. But with the key thing is having the provisions there to ensure the tenant protections is in place. You would obviously expect any lease to cover the standard repairing and insuring obligations and where these sit in relation to either landlord and tenant parties. But the importance of that from a reimbursement perspective is that this will identify whether or not the practice as tenant receives any additional sort of reimbursement level above the actual rental level that is paid to landlord to reflect these additional obligations that are due under the lease, of course. And this leads me very briefly on to touching on notional rent itself and versus a current market rent or reimbursement system. Notional rent being in respect of owner-occupied surgeries, whereas your current market rent or reimbursed rent relates to leased surgeries, and whereas notional rent would be reviewed every 3 years, your actual lease reimbursement is only reviewed in line with the lease, and if triggered, generally by the landlord only, as there can't really be a profit rent situation created in terms of your reimbursement under an approved NHS lease.
Perfect. Thank you very much, both. So kind of with that in mind, and I think this one is about how to maximise rental income. It's probably more specific to those in owner-occupied practices rather than leasehold premises, as you've mentioned, James, because there's no real benefit to a practice in a leasehold premises in maximising their rental income because they're just passing that on to the landlord. But if you're in an owner-occupied practices, is there things practices can do in terms of maximising that rental income, that notional rent that they receive from the NHS?
Yeah, so from a landlord's perspective or from an owner-occupied perspective, absolutely. Fundamentally, rental income tends to be driven by the standard of the premises, the standard and specification of the building itself as a surgery. It isn't entirely driven by that, but primarily so. So it follows that improving and enhancing rent should therefore assist in helping maximise capital values as well. Again, the caveat to that is that doesn't affect things like external market forces, but it helps maximise value where possible as a GP surgery. So it's things like to make internal improvements where possible to enhance the sustainability of the building, but to look at making the building more compliant where possible with the latest modern design guidance. So first of all, I would look at things like clinical space enhancements. Clearly, a surgery is driven by its clinical space, its consulting space. So it's enhancing and modernising clinical space internally, looking at things like accessibility, how patients and staff enter buildings, whether you're looking at manual access or you can improve it through some kind of automated access and level access systems, and also within the building itself. We look at Equality Act compliance, where we can possibly improve on the facilities and standard of things like accessible WCs and the provision of enhanced reception desk space. So overall, it's where we can modernise surgeries internally, can help drive both notional rent and rental values. Things like patient flow is particularly relevant, but again, it refers to things like how comparable is it with the latest surgery design guidance, and clearly it is more difficult for an older building generally to be modernised in this way, but they can be, than it would be for a more modern purpose-built surgery. And I'd touch here on things like challenging CMR assessments or notional rent assessments, which help again in terms of maximising that income stream. It's always important to have a look at these things, that these are checked. The district valuer has a huge job in assessing every building, every surgery in the country, and quite often they will look at historic records tied in with a recent inspection, but it's important to check whether this has been fully recognised in looking at things like the floor areas. Were they historically assessed, or do they need to be re-looked at? We agreed as recently as yesterday a case where the entire first floor of a surgery, nearly 250 square metres, was for some historic reason not assessed. And that's an extreme example, but there are examples out there. So it's important to look at scrutinising some of these where possible to ensure the floor areas are right, the rates, underlying rates are looked at, and things like approved space, whether that's changed over time, whether there's traditionally some non-approved GMS space that is being utilised that could be looked to be part of a business case to enhance the underlying rental income. All aspects like that can help to enhance rental income.
Perfect. Thank you ever so much, James. Okay, and so one of the big areas of dispute, I think, when it comes to leases is the repair and maintenance obligations within that lease. So what are the kind of best ways, practices to manage their repair and maintenance?
So I think it's particularly important, first and foremost, that the lease clearly sets out which parts of the premises are actually demised to the partners. So if it's an internal only repair and lease, under which the partners repair, maintain the internal parts and the landlord maintains the structure, the lease should clearly define the extent of the demise, so the internal walls, floors, etc., and the structure, so the structural parts, walls, floors, roof timbers, etc. I mean, whilst that may sound obvious, if it's set out in the clearest possible terms, then it avoids any disputes or arguments that you've just mentioned, Will. So it clearly sets out who's responsible for what, so it minimises any chance of arguments in the future over who's responsible for what. And then just in terms of managing the repairs and maintenance, so in terms of specific steps, I think in order to sort of, when negotiating the lease terms, partners should consider things such as trying to get a schedule condition, which could potentially limit repair liabilities during the lease term and the dilapidations liability at the end of the lease as well. And if it's an internal repair and lease under which the landlord sort of maintains the structure and charges the service charge, which is the common thing with IRI leases at part, then try and negotiate a service charge cap as well. And then with sort of full repair and leases where the lease covers the whole building and the partners assumes responsibility for everything, there is a 5% top up added to the open market rent under the rent reimbursements under the premises cost directions for repair maintenance liabilities. And what we always say, it's sort of a good idea to separate that sum from the other practice income and build a maintenance pot, if you like. So there's money there if there's any large or unexpected repairs, and that way obviously partners can avoid any big sort of dilapidations liabilities at the end of the lease. And I think that's why it's also important as well, just for partners to be proactive and inspect the premises on a regular basis, and if there are any potential issues or anything small, then they can catch those issues at an early stage before they become a big problem. And I think that goes for both FRI and ARI leases, really, just that proactive maintenance, just making sure those inspections are carried out on a regular basis.
It completely makes sense. And just to add to what you're saying, James, is that 5% can actually be more depending on the type of building itself. And I think using things like programs of programs of maintenance and things to look at establishing, utilising that budget to stop a cost spiralling can be helpful. Yeah,
definitely.
Perfect. Thank you both. So with all that in mind, what advice could you offer to practices who are looking at putting a lease in place or renewing their existing lease?
So I think basic housekeeping, I think, is a must. So when we talk about repair and liabilities, I mean, this goes for liabilities in general, but when we talk about premises repair liabilities in general, the liability should be documented in the partnership deed, which is particularly important to practices with multiple non-property owning partners, and making sure partners are getting advice from specialist advisors at the outset, particularly when it comes to negotiating heads of terms and the lease. So with the heads of terms, so they should be negotiated by obviously specialist GP surveyors to make sure the lease gives the partners that sufficient protection that they need. And then when those headline terms are agreed, making sure the lease itself is negotiated by solicitors with the knowledge and expertise of GP leases and the sort of quirks that come with it. I would just also say as well that one of the key things is ensuring that the ICB and the district value of the DV are on board at the earliest possible stage, because as has been mentioned before, they need to improve the lease and the amount of rent payable under it. And a DV approval can obviously take up to a year. So as I say, getting them on board at the earliest possible opportunity, reduces those chances of long delays, and it preserves rent reimbursement as well under the premises cost directions.
Perfect. Thank you ever so much, James. Okay, so that's covered everything to do with rental income and lease surgeries. So the next section is all about partnership succession. So what do partners need to think about in terms of succession and retirement planning?
Yeah, so I think that the important thing is that liability doesn't just automatically end when the partners notify the landlord of any proposed changes to a partnership. So partners need to take the necessary legal steps to transfer the title to ensure the outgoing partner is actually released from those obligations on their departure. So as we spoke about before with GP leases, having a properly drawn up GP lease should allow for partners to transfer the lease between themselves and allow the release of the outgoing partner. And then when a new partner joins, a deed of adherence should be entered into. So that essentially makes sure the incoming partner is actually bound to the terms of the existing partnership deed, particularly the premises lease obligations. And if there's a mortgage over the premises as well, then the outgoing partner needs to be released from their obligations to the lender as well. And if that's the case, it's important to check with lenders whether they've got specific requirements before the partner can be released.
Perfect. Thanks, James. And then from my point of view, I think there are plenty of options for kind of partners when looking at succession and retirement planning. I think the first option for most partners when they're looking at leaving is who's going to replace them. And I think it's just about if there's a partner leaving, are there salaried GPs or are there other members of staff who can potentially step into the partnership and take over the lease if they're in a leasehold premises, or potentially purchase that share in the premises if they're in an owner-occupied practice. But the thing, and I don't know how you all find it, but from my point of view, I seem to find a lot of practices are just struggling to recruit partners at the moment. There doesn't seem to be a huge amount of GPs wanting to become partners. There's obviously alternative partners practices can employ now in terms of nurse partners or practice managers or pharmacists who can step up into the partnership. But it seems to be really, really difficult for partners to find replacements. And I think that's a specific issue really in rural areas, but I think a lot of practices are really, really struggling with it. And I think there are alternative options to that. If partners are struggling with finding new partners when they retire, I think a good potential option is sale and leaseback. I don't know how you find it, but from my point of view, I seem to find that practices that are in leasehold premises just find it a little bit easier to recruit than those in owner-occupied practices, perhaps because incoming partners don't have to find what is often hundreds of thousands of pounds to buy into a small share of the practice, and they just have to become signatories on the lease, which obviously comes with its own risks and responsibilities and liabilities, but they're not having to go and find funds to try to buy into the practice. So I think sale and leaseback is a potential option when practices are thinking of succession and retirement planning, and that is effectively just selling the premises, still providing medical services from the building, still holding the contract, but they're just not having to worry about the ownership of the premises itself. An alternative option to that is potentially putting a lease in place. So when upon retirement, perhaps a partner doesn't want to actually sell their share in the premises, they want to keep hold of that investment, and they could potentially just put a lease in place. So they effectively become the landlord, they effectively become the investor, and they lease it back either to new partners coming in or the remaining existing partners who are already present. So two options really there to do with the premises. I think to do with the contract, if practices are worried about a kind of a last man standing option, they could look at potentially merging with another local practice. There seems to be quite a lot of conversations within practices within PCNs at the moment about inter-PCN mergers. I know of at least 2 PCNs who are actually looking at joining all their practices into one super practice, if you like. So I think there's a lot of talk of that. There's a lot of potential mergers. So I think if you're in a practice where you are worried about that last man standing, then perhaps approaching a local practice that have a larger partnership with more GP partners in there is a viable option. And if that isn't one, then potentially looking at transferring the contract to another entity. So there are, PCNs hold GMS contracts now. There's a GP federation that holds a GMS contract. There's also loads of third-party organisations that seem to be popping up all the time, looking at taking over contracts for that exact reason, for practices who are really struggling with that last man standing option. Companies that can come in and potentially just take over the contract, and perhaps certainly with these third-party organisations, they'd look at buying the premises as well. So there's certainly plenty of options there. The last option is closing the surgery and selling the premises, which, to be honest, I don't think any of us want to see happen. That really should be seen as a last resort. We had a practice a couple of years ago that had 3 GP partners that were all about 5 years away from retirement, and they all just panicked that they were going to be the last man standing. So they just agreed to hand back the contract and close the surgery down, and the patients were dispersed to all the local surgeries. And when I spoke to them, they weren't actually aware of what their alternative options were. It was too late for this particular practice. They'd already gone through the process, and I don't think the ICB were overly helpful in that particular area with providing potential alternative solutions to it. So yeah, I think it is a last resort really, but there are plenty of other alternative options to when considering kind of succession or retirement planning. So okay, so with that in mind, does anybody else have any kind of additional advice for practices to kind of put a succession plan in place?
Yeah, so I'd probably just again reiterate, just making sure the partnership deed is up to date as we've discussed, and all the liabilities are documented clearly in the deed and who's responsible for what. I would also say as well, routine checking the title to make sure it's up to date and registered in the correct names. So if a partner retires, removing their name from the title, or if a new partner joins, adding their name to the title. The experience tells us, unfortunately, this is something that's quite often overlooked, and it means that if a retired partner still names on the title, as we've sort of covered, then they're still at risk of remaining liable for mortgages or other lease liabilities and things like that until they're actually removed from the title. And it can also cause delays if the current partners need to deal with the premises, so if they need to assign it, for example, or transfer it on. So routine checking of a title is important as well, and solicitors can do a simple check of the land registry, just check the title to make sure all that's up to date.
Perfect, thanks James. Right, okay, so the final section, then we can move on to a bit of a Q&A after the summary, is all about funding options. So if you're a practice that's perhaps running out of space or in need of upgrades and improvements, I would say like 90% of practices that we speak to are after one of those 2 options. Then what kind of funding options are available to practices?
Thanks, Will. So I'll probably spend a little bit of time on answering this particular question. As you say, this is a situation that most of our GP clients find themselves in, where they're looking at funding both out of necessity in terms of finding space because of growing patient lists, adapting existing stock for primary care purposes, but also as part of future-proofing the practice in terms of succession planning, as you mentioned before, Will, just making sure the practice is attractive to new partners, and also just making sure the practice premises is suitable for the new primary care model, and what that might look like in the future with the NHS 10-year plan. So in terms of looking at the various funding options, we will have a list there on the screen. Each has their own merits, and actually often works, and we see that often works are funded by a combination of these options, and we could probably spend a whole session going through each of these areas, looking at the pros and cons. But I guess the message I want to get across today is the fact that there are a number of options available. I know sometimes our GP clients might just think they might be offered one method of funding and then perhaps not look at different ways in funding that, and actually what might work with their premises. And we often say, if you are thinking about extension works, in any way, to first have that conversation with your ICB contact, just so you can explore some of these options and see actually which option is available to you. So the first one we have there is capital reserves. And James briefly touched on this earlier, where this can be where we're in rental property, for instance, and we build up that pot of money. So with rental premises, you might have your rent top up there, which you can just easily build up that top of money, which again is attractive to new partners coming in, but also allows you to carry out those scheduled repairs and maintenance as a first and primary option, really. And the second option, which is a traditional method of raising finance on owner-occupied premises, is via a mortgage from either high street lenders, secondary lenders who still see primary care as a strong sector, with a guaranteed income stream, often reflected in more favourable terms. So that's something we deal with on a daily basis with bank funding. So that's one of your obvious funding options there. The next one I have there is the NHS grants. Now, traditionally under the premises cost directions, we could only fund improvements up to 66% of the project cost, which meant then you had to use a combination of these methods to top up the costs of the project. So it got quite complicated and perhaps limited some of the works that might need doing for the practice. So now under the 2024 directions, up to 100% of the project costs can now be funded, which is a huge improvement from the previous 66% cap. And also, not only can we fund the building improvements, refurbishment and fit out works for new or existing premises, we can also fund land purchases for some of these schemes as well. And it's really interesting. We have one of these on at the moment where we're purchasing neighbouring land for an extension of the premises. And we've had calls with NHS England just to talk to them about how that would work, how that would be funded, because traditionally the practice would incur that cost themselves from a cash flow point of view, and then obviously get those funds reimbursed from NHS England. But obviously when you're looking at a land purchase, we're often talking of quite a lot of money, particularly when we think about those marriage values we talked about earlier. So in those situations, NHS England confirmed that actually, they can fund the purchase of the land up front, so it saves the practice having to dip into their capital reserves or look at alternative finance for the purchase of the land. So that's a huge improvement under the 2024 premises directions. And obviously we have the UMF funding, which we're dealing with at the moment. We're acting for a number of practices across the country who are hoping to benefit from this scheme, and we deal with a lot of the grant documentation for that. That was something that was made available for this financial year, and we're hoping that that's going to be rolled across in some shape or form for next financial year as well. I'll probably leave James to talk about the abatement side of it in a second, but just to point out from a legal point of view, there are often conditions attached to this type of funding, which obviously lawyers can advise on. We see these things all the time. We know these documents inside out. So there are conditions attached, which can include legal charges, particularly if the funding is above the threshold of 144,000. So again, before entering into these documents, it really is worth taking advice on that. Before I move on to the next bit of funding, James, do you want to just mention a little bit about the abatement side of it?
Yeah, absolutely. Yeah, I assume you mean me, James, not the other.
Yeah, sorry.
Exactly.
Different nicknames.
If NHS capital is funded towards improvements or extension work there, it will lead to an abatement, and the period of abatement is set out in the premises cost directions. It's directly proportionate or linked to the scale of the funding itself. But for practices that aren't familiar with abatements themselves, it isn't an abatement of or a clawback against existing levels of notional rent. The abatement works by reducing the notional rent assessment going forwards, so it wouldn't be the full value of the improvement works themselves. It's that level that it is reduced. It's not the existing level of notional rent, but it's important to look at that in terms of funding options to establish the return the practice could get in terms of how they fund or proportionately fund any improvement scheme works versus if they have some reserves, whether they fund it themselves, critically with ICB support. But that's fundamentally, I think, to be aware of abatement side of things. Yeah.
It's quite interesting to talk about those abatement periods, James. We have some clients who are quite switched on in this regard, and they'll look at the abatement periods and work out from their retirement how long they want that retirement to be, just to help with succession planning. So and it's some things that practices are not aware of, so it's just worth having a look at those and just see in terms of funding where that tips you in terms of the abatement period. We've had some clients where it tips them into the next bracket, if you like. They think, well, actually, we'll limit the funding that we get from the NHS grant, and instead we'll take a little bit more from our bank lender, and work it out that way to limit the abatement period. So you can look at the different options there, which is really, really useful. Just to move on to the other options then. So they're, I guess, the most common options in terms of funding works to GP practices. But some of the other options which we see, we've got SIL funding, so that's Community Infrastructure Levy, or the Section 106 monies. This is something that's often overlooked, but we see this more and more as patient lists grow, particularly due to new housing developments, where funds can be made available not only for new premises, but also for improvement works and extensions to existing premises, generally to provide additional clinical space to meet the needs of that growing community. And again, traditionally, there's been no limit on the amount of funds that can be made available for this. So, and it will differ scheme by scheme. So with some of the examples I've been involved in, it was actually the ICB who highlighted the availability of this particular funding option to one of our clients, who was successful in obtaining funding for 100% of the works. These were extension works. And crucially, for this particular agreement with the local authority didn't require a legal charge over the property. So, and this was quite a substantial sum of money as well. So it was quite attractive for that particular practice who already had lending secured on the property, and just gives that flexibility going forwards without having that legal charge there. So it's really worth looking at that as an option if that is available, particularly if your practice is near any new development schemes. And then that brings us nicely on to landlord funded work. So this is obviously with leasehold premises where your landlord may fund new development schemes. And if you're looking to move practice particularly into more purpose-built premises, or as a result of a merger or general succession planning for the practice, that's an option that might be available to you as well. So just worth bearing that in mind. It's worth me saying at this point that the documentation involved actually with most of these, obviously not excluding capital reserves, which is a bit more straightforward, but most of the documents here involve legal charges, development agreements, grant agreements, mortgages, all very, very complicated, and all will have some type of strings attached. And when we're talking with GPs as well, we're talking personal liability in a lot of these situations. So it's worth going in with your eyes open and getting proper structured advice before we enter into any of these documents.
Perfect. Thank you ever so much. And this is probably an impossible question to ask, but is there kind of a funding option that's best? I guess it's probably just a case of being unique to every individual practice and a very specific to the individuals. But yeah, do you have one that is better than another, or?
Yeah, absolutely. I mean, I agree with you, Will. It's going to depend, which is a good lawyer answer, isn't it? It will depend scheme by scheme on which option is best for you. But I think the starting point, as I mentioned earlier, is to speak to the ICB, who will look at this from a strategic point of view, and also to look at the strings attached to each of these options as well. In some cases, not, but also. For instance, I mentioned a legal charge before. Is the funding option you're looking at subject to a legal charge over the property, which may limit things going forward? So obviously bank financing, you are going to be subject to a legal charge. Your NHS grant, if it's over 144,000, you will be. Some of the others you might not be. So obviously if you can avoid legal charges and look at those types of options, that's always going to be a good place to start. But also just being aware of any termination payments under any of these agreements as well. So it's typical of improvement grants that they're linked to use, and some of these termination payments we've seen can be quite substantial and a huge liability to hang over the partners. So it's just worth understanding those beforehand before going into those agreements. And with leasehold property, looking at that option, just being aware that you might be required to commit to quite a long lease, which technically can't be terminated in in any situation. So we just need to make sure that we do fully have the support of the ICB there. If necessary, have subsidy agreements in the background or whatever assurances we can get hold of to make sure that we're not, as GP partners, been put at risk in terms of the option that we do go for.
And as you say, Lisa, I think any value for money report that the district valuer would issue in relation to any proposals for improvements based on NHS funding, they will identify any abatements going forward. It's important to understand the extent to which they would apply and how long they would be relevant for. So it's discussion in each and every case with the commissioners and with advisors. Yeah.
Perfect. Thank you ever so much, both. I think we've covered nearly everything, but there's any kind of additional advice to practices on funding options before we wrap it up?
Thanks. Well, I'm conscious of time as well, just looking at time here. So I'll canter through my bits from a legal point, and it's basically summarising what I've said. So again, it's a housekeeping plea. You know, these options attract personal liability. So just need to really be careful. I think James mentioned earlier on about making sure you're released from liabilities under this funding, under any funding agreements before you retire. So that's something really to look at and plan ahead rather than it catch you out last minute. Keeping your title up to date, as James mentioned previously, to make sure we're dealing with the correct partners and funding isn't delayed, because we need to sort that out. And then the last point on this from me is, as I've mentioned, to engage commissioner and specialist advice before contemplating works. Make sure you've got a robust business plan before we proceed with any plans, to ensure you're not out of pocket. And actually, a lot of practices say to me, when can we start spending money? When can we start proceeding without any risk from our point of view? Which is a really difficult question to ask, because we as lawyers, we're going to say, don't spend any money, don't start works until we've got legally binding agreements in place. But we know in reality that that's quite difficult, and a lot of costs need to be spent actually before you get to that stage, in terms of architect fees, looking at plans, planning fees. So having that healthy capital reserve is advisable no matter which funding option we go for.
And just to reiterate what you've said, Lisa, is ICB approvals are absolutely critical. We still see premises that have been extended potentially years ago that have not been approved. There is no reimbursement for that GMS space that is being used for GMS spaces.
We've seen that as well, James.
So it's really critical that that process is followed in engagement with the commissioners.
So my summary quickly, I've mentioned it all. Good housekeeping, keep your partnership deed and your legal title up to date. Build up that reserve fund we talked about, and how it's governed will be dictated by the partnership agreement. Use specialist advisors, as we've mentioned. Get the ICB involved at an early stage, and crucially, plan ahead. Don't leave these things till the last minute, just to make sure we are prepared for the future.
And from my side, engagement with the valuer when having valuations prepared, be as transparent as possible, query anything that is not unclear, and try to understand exactly how a valuation has been arrived at as part of the process. Again, as Lisa said, ensure specialist advisors are utilised either in the lease negotiations or during any dispute that may arise during the course of a lease. It's critical to get ICB approvals for improvement or expansion space proposals, and obviously in terms of rental maximisation, ensure notional rent's maximised and any income streams are also.
I think from looking at it purely from a legal perspective, and actually on the premises side of things, we need to make sure whoever is ultimately in occupation of the premises, i.e. the GP partners, are the same people who are on the GMS contract. So, and where that doesn't align, we'll have problems with rent reimbursement. So it's very rare in these situations to find, to deal with a corporate entity where we're not talking about GP federations, and in which stage we still need to then put a lease in place to the partners. So it starts getting very, very complicated. So unless there's any specific tax advice, why that structure is in place, generally it's still the old-fashioned traditional partnership model we do see with GP premises at this stage. But we never know, with obviously the 10-year plan, what's happening in the future and the new neighbourhood contracts, how that's all going to work. And we do see a lot of our clients getting prepared and setting up companies for that purpose, but actually GMS contracts are going nowhere, GP practices are going nowhere, and I think the partnership model will still be very important for those purposes, particularly when it comes to premises. I think, well, when we talk about a trust for legal purposes, any property which is owned by more than one individual is held by trust anyway. So it will be held in trust in accordance with the terms of the partnership deed from time to time. So it will be the terms of the partnership deed, i.e. the trust document, which will dictate what needs to happen on retirement. So it's really important you get good advice on that.
Hi, Lisa. Sorry, Justin Cumbridge from Hempsons. First of all, Lisa, thank you very much for pushing work our way and talking about the partnership deed.
Yeah.
Well, what I would say is, just pushing it back, if you own your premises, which are probably the most valuable asset that you have, you should really think about a declaration of trust, having a trust deed which deals with the premises. And one of the reasons I say that is because a partnership deed can fall away simply by the fact that you bring in a new partner and you do not update your deed. They do not join into your partnership deed. And so the Partnership Act would apply, and then all the partners have an equal share of the partnership assets. So in essence, you have just given away a proportion of the value of your premises to the new partner inadvertently. So really think about having a trust deed, or declaration of trust, if you own your premises. I just wanted to add that.
Thanks, Justin. And it's worth saying as well, where there is a declaration of trust, like with a partnership deed, it's really important to keep that up to date as well, because it's only going to bind the partners which own the property at that time. It's a little bit easier to keep track of, because obviously once you're transferring legal title in a property, the fact that there is a declaration of trust you will be notified at that time, so it kind of prompts you a bit more to make sure that document's up to date as well. Otherwise, that's not going to be worth anything either. So either way, I think it just shows the importance of good housekeeping and keeping those documents up to date, and make sure the current property owning partners are party to those documents and bound by the terms.
So I touched on this briefly during when I was talking earlier. It's fairly common that there will be some kind of private tenancy in place. It's how we treat that within the valuation that's important. But quite often, if there's something there, it will be reflected depending on the purpose and the assumptions made within the valuation.
I guess I'll pick that one up first. Firstly, the lease renews. The existing lease, I understand, comes to an end in a couple of years. So well done for thinking of this ahead of time and the options available to you. There's going to be lots of variables here. Is the existing lease within the 1954 Act? Do you have security of tenure? Who is the landlord? Who are we dealing with in this instance? Usually I'd expect a 25-year lease to be in respect of new premises. Obviously, the landlord in those situations are making a huge investment in the premises, so often do want 25-year leases signed. Outside of that, it is rarer to get leases of that length. Usually, we're probably talking around 15 years is the norm. But again, it's all at heads of term stage, all getting advice from surveyors like these guys here to make sure that everyone's happy with the terms, and also to make sure those terms are approved as well by the ICB, because that could affect the level of rent as well. So advice is to speak to these guys and look at some advice on heads of terms, so that can be negotiated to a point where all the partners are happy with it.
I think this particular query comes from a Welsh query. So again, the SES in terms of shared services will look at what they will approve and or not. And if it's an older building, they won't approve something like a 20 or 25-year lease anyway. So yeah, get some representation, I think.
I'm just wondering if by this question the landlord might, are we looking at a landlord such as NHSPS or CHP? Are we looking at those types of leases here, which sometimes does attract the issues with maintenance and service charge? So, but otherwise, again, it is going to depend a lot on like we talked about before with heads of terms and the nature of the building. Nature of the lease as well. So that's something you'll perhaps be best advised to take specialist advice on the actual terms of that lease. How long is a piece of string, James? I guess this one, isn't it? This is the $1 million question. But I think we deal with these a lot and we get involved at very early stages. And I would just say, if you've got a need, it's all about need in the community as well. Is there a need for more space? Most practices do need more space. They need their the premises updating to modern standards. Whatever that case may be, I'd suggest you speak to the ICB about it and have a discussion with them as to what funding options are available and what they will support. I will say with this UMF funding, some of my clients were looking at smaller grants originally because they didn't think too much of the fund would be available for each practice. But as we've gone on and the fund hasn't been spent, seems to be more of a willingness for bigger projects to be supported. So if you don't ask, you don't get. So I just suggest speaking to the ICB, putting a good business case together and go from there, really.
The criteria for UMF or utilisation and modernisation funding tends to be related to the creation of additional clinical space, but within established approved footprint space. However, there seems to be a lot of grey areas that are still around that can be with assistance from supportive ICBs. But otherwise, as Lisa says, it's driven by need, really.
Yeah, absolutely. Yeah, I think that's the problem. I don't think there is any particular methodology of working this out, and it does differ between local authorities. So, and some seem to be more willing to invest than others. So I think it is going to depend on region, depend on need, as we've talked about before. And really the best way of getting involved is to speak to the ICB in your particular area. Sorry, Bryn, do you want to come in on that one?
Yeah, sorry, just to add to that, sorry, Bryn Morgan, another partner at Hempsons, you've got loads of us today. I'm afraid. Just to say that I think it's really when you see planning applications go through, get online, look at most councils have, you type in the address of the property, and it will show you'll get all the documents up there online showing, the planning application, the planning reports, what's involved. When the planning permission's granted, if there's a Section 106 agreement, you can get a copy of it, and it will tell you how much money is allocated to healthcare, what the provision is. So you kind of get that, you get those headline. And then you can go and ask and say, well, look, ICB, I can see we've got this new planning permission's been granted, and it's got X number of pounds for healthcare, primary care improvements. How do I get hold of it? So I think it goes back to being proactive and having your ear to the ground and seeing what's going on.
The key thing from my perspective is not impacting GMS reimbursement, and the key thing with any undertaking any out of hours, whether it impacts the provision of that space. It's a bit of a grey area, and the directions historically referred to private income and how it could be apportioned and deducted potentially from the contract reimbursement. But every ICB was historically dealing with it in a slightly different way. The key thing now is if there are private elements or there are aspects that are non-GMS, that they aren't included within the GMS reimbursement. But if this is out of hours, I think it's looking at it very cautiously to see how it would affect overall reimbursement, and engaging, if necessary, with sort of the commissioners to see how that might impact things.
Just on that last question, essentially, if you're a contractor, you cannot use any of the space within your premises for private practice. If it is separately rated, then you can argue it as separate space, and therefore, and obviously it's not reimbursed and it's separately rated, then you can use it. out of hours. In other words, were not your contracted hours. There is a bit of a loophole that it relates to contractors, and therefore there is a question as to whether in fact you are a contractor if you're not one of the partners. So if you're a salaried GP and you then use the premises, are you in breach of those that regulation, which was looking to close the loophole of essentially NHS paid for premises being used for private practice? But tread very, very cautiously, I would say, in allowing anything like that. If you want to do private practice, get some separate premises and do it separately outside your normal contracted hours.
Thank you
very much.
Thanks, everyone. Have a great day.